ipilit ang deklarasyon at tuluyang pagpapairal ng batas militar noon. Tugon ni Ginoong Sagisag, good Filipinos gaya ng good Germans ni Hitler. Gaya ng mga abogado noon sa Alemanya who obeyed as law anything calling itself by that name and was printed at government expense. Nuremberg ruled. That was wrong. Okay. Yung pagmuli, sa inyong pakiwari sa konteksto ng kontemporaryong kulturang kritikal at katangian ng Hudikatura, maaari pa kayang maulit ang pagmamanipula ng konstitusyon at ang pagbabraso ng eksekutibo sa ngayon ng pamahalaan dito. Tugon ni Ginoong Sagisag, nangyari ito kay ERA na sinabi ng Korting Suprema na nag-resign based sa Angara Diaries. We have to be eternally vigilant. So, yun po ang sagot ni Ginoong Sagisag sa 4 na tanong na dapat sagutin sa panayam na ito. Meron pong comments, not necessarily questions, but comments from the floor. Pasensya na po dahil linalaro pa po ng anghel itong ating mga audience nung martial law. Pero magandang pagkakataon ho na alamin natin, no, kung ano nangyari. Okay. Marites.
I just wanted to share that I was looking for the Marcos papers. I asked Manolo Quezon, meaning hindi lang mo yung diaries, pero yung mga letters, memos, yung mga naiwan lahat sa Malacanang. Sabi ni Manolo Quezon, nasira yung iba, nabasa ng ulan, yung iba nasa National Archives. So we still have to go to the archives to check, baka nandun pa yung iba. Pero sayang kung maybe UP can do a project. Sayang, but Manolo Quezon was quite helpful in directing me. Kasi gusto ko lang makita sana yung, ano ba yung mga, aside from the diaries, ano bang mga official letters niya, memos. Kasi he always wrote. Marcos was always writing. Hindi siya masyadong, he kept notes of a lot of things that he did.
There was before a rumor that UP wanted all the presidential papers here, and close to, I don't know if within the Diliman campus or close to it, but it really never materialized because it would have been good that we have all the presidential papers intact in one place. As of now, in the National Library, you have the Quezon papers, I think, the Quezon papers. The Rojas papers are here in the UP main library, but people have not really, taken a look. Maganda rin, I can imagine, the Rojas papers because it's a post-war Philippine situation. So, but the Rojas papers are here in the main library, in our university archives. Pero yun na nga, maganda sana kung matipon lahat. Baka baka tinago rin ng Marcos family yung ibang papers, no? So, it would be a good project if talagang we have a law again, na all papers of the president should be surrendered to a particular institution, no? For the future generation to consult, use. Comments from the floor, questions? Please introduce yourself.
Rally po, sa Asian Center. Nagtataka lang kami bakit yung mga estudyante hindi nagtatanong sila yung magmamana nitong mga sinasabi ng mga magsalita. But anyway, ayaw nila, so kami na lang. Well, isa po, curious ako kung ano yung relasyon ng kasaysayan, history, at saka ng law sa long-term na perspective. Mukhang magkaiba yung judgment ng dalawang spheres na ito. Lalo na sa usapin ng demokrasya. Pag historical, mukhang lumalambot habang tumatagal. Parang maging human. Dati, galit na galit yung mga tao sa mga diktador, pero over the long term, nakikita na nila yung human side ng mga diktador at ng mga nagmana ng kanilang kayamanan, ng kanilang poder, not to mention ng kanilang apelido. Pero yung law, on the other hand, naiiwanan yung kanyang sinasabi at that particular period. And it's good, merong record yun. Kaya lang, I doubt kung makakatulong yung batas para doon sa longer term na judgment na history. No? Parang magkaiba yung perspektiba na mangyayari. Ibig sabihin, well, on a bigger scale, sino ba talaga yung drawing ng legal infrastructure ng isang demokrasya? Yung bang iba-ibang sangay ng gobyerno, yung bang presidente, o yung iba-ibang may ideolohiya, yung liberalismo yung pinabanggit ni Dr. Pangalangan, realist na kumukontra sa ganyung pagtingin, o yung mga tao in their large numbers. Kasi it seems, meron din ibang dynamic yung pwersa galing sa labas, no? Labas doon sa mismong logic ng political, legal parameters ng Estado. Naintindihan ba ako? Siguro. Salamat po.
Kanina mo gusto
Kasi naman po yun.
okay. Unahin na natin sila.
Well, Rolly, thank you for the thank you, Professor Talampas, for the question. I'll attempt, Rolly. First, I recall that at the height of the human rights litigation during Marcos years, if I recall right, this is a quote of Joe Arroyo. He was asked, bakit kayo file ng kaso na tatalo naman kayo? And his answer was, we have to file the cases to document the events, because the cases will be the official record of what happened. And we must keep on filing the cases so that the courts will, even if you lose the case, the courts will have a record of the events that happened. And that is why, going back to the question of Dr. Kamagay and Marites, in fact, you can write a history of martial law just purely by the cases. I attempted that in one of my charts, that every big event can be traced to a case or to a legal issuance by Marcos. And you can actually match what Marcos did after the Plaza Miranda bombing, what he did after, those two boats carrying guns from China that ran aground in Palanan, Isabela, MD Karagatan. In other words, the big events will always have a mirror in legal, in terms of legal documentation. So, but that's the most crass level of answering about the role of the lawyers vis-a-vis history. I'd like to address Ronnie's point that the historians can have a more, I don't know how you will describe it, a more humane or a more flexible judgment. And legal analysis remain fixed, rigid, and stiff. I think it is, for me, I'll answer at two levels. First is that there is a built-in ideology for law that is encoded into the Constitution. In other words, the way I describe the 87 Constitution, it will be a hodgepodge of left-wing goals carried out through liberal language. And that's encoded in the document, and then it's stiff. You have to work within that framework. So they don't have much room to maneuver in. But I'd like to close with this point. It actually goes into the Pinoy attitude to language and to rules. Pinoys are schizoid about rules Sometimes they want the literal application of the rules, but sometimes they want a more common sense reading of the rules. And we can't tell which, being schizoid, which Pinoy we're talking to at a given moment. We encounter it. We deal with the UP bureaucracy. Sometimes we are aghast at the narrowest, most legalistic reading of rules, and sometimes we actually applaud the very technical reading of the rules. So I actually am a bit sympathetic to the courts and to bureaucrats because they don't know at what stage, what kind of interpretive leeway they're supposed to exercise at a given point. And that's demonstrated by Javeliana, or for that matter, the Davide impeachment. Notice for the Davide impeachment, we were very literal with the rules. I was amicus counsel for the case, and I actually articulated that during the oral argument, that we can't be this literal. But I think, Rolly, at that stage, it is not about ideology anymore. It's pure legal, pure theory of law, pure jurisprudence. Thank you.
Pwede makakulit. Hindi kaya complicit yung left doon sa nag-evolve na legal thinking, legal framework na inadapt ni Marcos and his friends. They gave all the excuses for Marcos to develop fully the legal mechanisms for...
Okay. That's a nice approach, Ronnie. In hindsight, you can say yes, right? It was almost like a script. He needed to write the script. It's almost like, again, we're not going to some conspiratorial theory of he talking to Joma, but it's almost like the two guys, two smart guys, knew what the other wanted, and it was like a ballet, like coordination between the two. And I think objectively one can say that. They supplied one another with what the other needed at that point in history. So the throwing of the grenade at Plaza Miranda, from the standpoint of the left, would sharpen class contradictions, intensify the revolution. For Marcos, it provided him an excuse to suspend the writ of habeas corpus. He declares martial law. It pushes all the above-ground student activists to go underground and actually help the NPA, the underground recruit more people. So that there was that dynamic, whether it was deliberate, conscious, and conspiratorial. Like, of course, well, I don't know, but in a sense, they worked well together. But Ronnie, in terms of the discourse, actually, if you look at the Marxist interpretation of rules, they are actually as positivist as the traditional Pinoy positivists. In other words, they will be as literal about the rules as possible. No different from Pinoy bureaucrats. In other words, the apparatchik of the Bolsheviks will be no different from the apparatchiks of UP. They may carry out a different ideology, they may swear by a different flag, but their attitude about interpretive leeway over the rules is just as confined and as textual. I'll pause on that one.
Okay. Can we, I recognize Ms. Bugnosen. Student.
Hello, good afternoon everyone. I'm Monique and yes, I'm a student of Ma'am Kamagay in one of her classes, and I'm also a pol-sci student here in CSSP. Actually, I only came here and I only listened to Ma'am Vitug's speech, and actually I was caught. I didn't really know that Puno was somehow a conspirator or someone who is in the martial law. And when I was in high school, that was the time when he was Chief Justice. So I my image of him now has changed. But I'd just like to know, since most of us here are, young, most of us here are students, could you name some prominent people, siguro, lawyers or members of the Supreme Court who are still, siguro right now, still prominent? Last year, in UP, naging issue ang Virata because yun nga ho, he was part of the Marcos administration, and then yung CBA named the school after him. So maybe in terms po of in the judiciary, sino pa po yung mga prominent members of judiciary or even lawyers who are still prominent now, so that we could know, as students could know who are these people who are actually part of the martial law. Or sige po, si Dean Pangalangan.
Well, mostly it's a generational thing. They're all retired by now. So, for instance, I'm surprised that you are surprised that Chief Justice Puno, once upon a time, was one of the lawyers in the Office of the Solicitor General. Well, this is borne out by the record. In fact, one of the challenges to EDSA 1 is entitled Letter of Renato Puno to the Supreme Court. That's the title of the case. Because when Cory took over, she demanded the resignation of all the justices, reappointed them, and changed the seniority. And he wanted his old seniority. And so he was one of the challengers. So for me, they're mostly retired by now. And if some are still in active practice, I can't recall. Well, the classmate of Dean Bacungan was Joker Arroy, and Joker was in the Mabini. Was part of Mabini together with our scheduled speaker, Rene Sadisa. Well, the other difficulty, Monique, is that part of Philippine politics also is that exactly the same way that you were surprised that Puno had roots in justifying the dictatorship. They changed their roles over time. And even some of the anti-dictatorship guys would eventually be identified with some questionable factions. I'm not attuned to the names. If nothing leaps to the mind right now. Well, I'm sorry, I can't document it. Yes.
Hi, Monique. I remember I interviewed Chief Justice Puno when he was new as Chief Justice, and I asked him, what can you say about your defense of martial law? And he said he was just doing his job then as part of the Solicitor General, and that was a different time in his career. So now, as Supreme Court Chief Justice, he's now a defender of human rights. So he said it was only part of his job. I think the other prominent personalities who are still around, President Fidel Ramos, although he wasn't as stern and as his reputation is not as notorious as Senator Juan Ponce Enrile, but he was there during martial law. Of course, Juan Ponce Enrile, and the Accra Law Office, Raul, some in the Accra Law Office, right? Or was it just Enrile at the time? Anyway, Enrile in his memoir said that he founded the Accra Law Office during the martial law years.
There, you would like to ask?
Yeah, because I thought you will talk about your own memoirs. Di ba, you were a journalist when martial law was in the peak of things. But you based what you said about from Marcos diaries and your interviews. I was hoping you will put your own memoirs about martial.
I was, just to clarify, I was young, very young then. I was a freshman at UP here. I entered in 71 after the Diliman commune. So that's why I'm interested in the period. So I try to look at sources.
Yes, the student, please introduce yourself.
Good afternoon po. Estudyante po ako ng Asian Center, Philippine Studies, Raya Manalo. So, question ko po in connection with the post-Marcos era. Ano po yung tingin nyo dun sa kung ang Marcos dictatorship ay legal in accordance with the 1935 Constitution? Ano po yung opinion nyo dun sa extra-constitutional process ng pag-upo kay Era at kay Arroyo na ano po yung opinion nyo sa people power as a process? Okay.
Okay, yes.
Well, thank you. Your name is Gaya. Gaya, thank you for the question. Well, I have written on this quite extensively. For me, the people power is difficult to fit into strict into a constitutional straitjacket, and that is why for EDSA 1 we had to use the political question doctrine. The court says, what can we do? She's now there. If the Marcos metaphor was to unscramble the egg which was scrambled, the metaphor of the court for EDSA 2 was to put the toothpaste back in the tube. So in other words, just to show you, over the years, they've tried about every metaphor from scrambled eggs to toothpaste, just to describe what they were doing, because it's so difficult to do it. So yes, we fit EDSA 1 and EDSA 2 within the constitutional framework. It was really forced, and that is why, that's precisely my point. Maybe we should just be candid that something strange happened and we moved on. Because if we force them to fit the Constitution, we distort the constitutional order. So with EDSA 2, the resignation of ERA, the guy never really resigned, but he exited Malacanang from the back door. He crossed Pasig River on a boat. He had the Angara diaries, and then the court says, well, look, and then the court had to invent words. The totality of contemporaneous circumstances lead us to the concept of constructive resignation. You know what? It is an exception to the rules. Short answer, no, it doesn't fit the Constitution. But we have lived with it because the only way to justify and legitimize what began to transform the de facto situation to de jure. I am actually more particular, and here Malu and Marites, about the perception of the Filipino public. I don't know, Marites, if you remember this. EDSA 2, GMA took the oath on a Saturday. By Monday, what was the headline of the newspapers? It was Gloria playing golf at a really fancy golf course. And for me, it shows the class character of the uprising that overthrew her. They love to see their new president rubbing elbows with the rich and mighty, and playing golf at this place where you pay X millions just to get past the front gate. So, and for me, it was rather disappointing that we packaged it as a people power uprising. When, as Time magazine lampooned the uprising, it was actually rich people's power. And so that is why, again, to go back to your question, If you want to look at it purely as a constitutional question, then sure, it's a game we lawyers love to play. We can kick the doctrines comfortably. You know, for me, the metaphor really is playing soccer. You kick the ball around, or maybe playing frisbee. It's a game. It's a nice game. We'll have fun doing it. But does it add to the legitimacy of the entire enterprise? My position is it doesn't. True legitimacy will have to be rooted in deeper social concerns about social inequality, about class power, about the concentration of wealth among the few in the Philippines. But precisely that is the debate which is shunted out as soon as you shift to this to the legalistic mush that we traffic in, that we profit from in alcohol. But that's precisely my conundrum. The Filipino public loves legal debate, and despite the fact that I've been so disappointed often enough in the past, and that the contrived nature of the debate has been exposed often enough, but it persists. So for me, that is the mystery. I think it is the allure lies in the promise that it is possible to have the equal protection of the laws and genuine freedom of speech, etc. And maybe we need the illusion, and that is why we hang on to the legal discourse.
Meron pa tanong? So siguro ay sa puntong ito, hindi kong pasalamatan ang ating mga tagapagsalita ngayong hapon.